Your Honor, this is Bill Fields again. I think I might have gone, or I should have said before I started asking questions that I wasn't really intending to ask anything in confidential session, and I don't think I did.
You did not. That was okay.
But perhaps that could be corrected with the record. I'm not sure.
Okay. We are back live in case number 9666. Counsel for U.S. Wind concluded their non-confidential examination of the witness, followed by an examination by Mr. Fields, which was public, but we restarted the stream a little bit late. At this point, the commissioners will have an opportunity to ask questions of the witness. Commissioner Herman.
Thank you, Mr. Chairman. Good afternoon, Ms. Scheller, and thank you so much for being here. We very much appreciate it. So earlier today, I don't know, were you listening when Mr. Chang was on the record?
Yes, I was.
Okay. So Mr. Chang, I went through his charts and he told me that some of the inputs from his charts were in your worksheets, I think, or workbooks. Have those been admitted as part of the workbooks he was referencing? Are the numbers we were talking about, are they included in the report that we have, that we admitted today?
The one thing I specifically recall he mentioned was the output of the facilities after curtailment, which is from those spreadsheets. I don't believe they are in the document. I believe they're only in the spreadsheets.
So if would you have any concern if I asked about having those put into the record as well, the spreadsheets?
I don't. I mean, the spreadsheets contain confidential information. I don't see why they wouldn't be a part of the record.
Okay. I'll ask your counsel. Are we okay? Are we okay having those put into the record?
If the commission would like them, I see no reason, as long as we mark it confidential, ma'am.
Okay. I think I'd like to have that in case, in case we need to make reference to them in an order. I think it would be helpful, so that we don't, we have a complete record. So I think we can do it. You can either file them as a response to a commission data request and get them admitted into the record. I don't know if any of the parties would object to that coming in.
No objection.
No objection.
Thank you. Okay, thank you very much, Ms. Scheller. Okay, so I am looking at page 27 of the report. On the bottom of the page.
I'm there with you.
Okay, and that doesn't appear to be confidential, right? After it ends, the end confidential and proprietary. From there down is all public, right? Or is it confidential but not oh, it does appear to be confidential.
Yeah.
Okay.
Yeah, I think it's.
Well, let me just ask you. I can ask you generally. You at the bottom of that paragraph about a condition. You're suggesting we condition any grants of OREX. Is that something that you continue to believe we should do?
I do think that it's referring to the.
We're not in confidential session, so I'm trying to just sort of say without saying what the condition is or that sort of thing. I'm not exactly sure why that's confidential, but since it's labeled confidential, I'll just ask if you think it's still something that we should include in our order that's appropriate.
I do think it's still appropriate, yes.
Okay, thank you. Just wanted to, because I hadn't seen that elsewhere. I wanted to make sure that was something that was still appropriate. I wanted to ask you a little bit about the economic benefits. And I don't know if you were listening, but there was some testimony earlier this week talking about Skipjack had a dollar figure, and Mr. Gunderson, I don't think that's a confidential figure, is it?
The committed spend figure?
Right.
No, that's not confidential.
Okay. It was $400 million. That's the number. That's okay, right, Mr. Gunderson? All right.
Yes.
And Skipjack had a $400 million commitment. But then, and Skipjack was suggesting that the U.S. Wind didn't have a specific number, that it was 19% of their in-state spend, and that was a variable. Did that have any impact on the way that you reviewed the economic analysis, with one company having one bidder having a specific number and another one having a less known number?
It did not impact our quantitative assessment, which really relied on the estimates, the value estimates that were provided by each of the bidders for what their expenditures in Maryland would be.
Mhm.
The review of the qualitative report, it had some bearing, but I wouldn't say that it was a major contributor to the rankings there.
Okay, thank you. So I don't know how much of an opportunity you've had to listen in on the hearings all week, but there's been some discussion by me that the assumptions in your report are conservative compared to the assumptions in Skipjack's analysis, and that is, much, that are they have much higher impacts of impacts on the market and that sort of thing. So do you have any comment on, I feel like we're kind of far apart on, we have a very conservative estimate, and I understand why we're being conservative, and we have what I've called more aggressive estimates, which I also understand why we would want to look at that as something to be, looking forward. So, but we don't have anything in the middle. So do you have any comment on the conservative nature of what I'll call conservative nature of the ICF report in comparison to the Skipjack analysis?
Yeah. I mean, I think I could comment on a number of different factors between the two analyses. From my review of the work, I think that there are two parts to the Skipjack analysis. One is the production cost analysis that was performed by PA Consulting, and the second part is the rate impact analysis that was performed by Bates White. In looking at the assumptions for the first part, the production cost analysis, I don't think it was as aggressive as the Bates White analysis was. I think there's some inconsistencies between the two of them. Overall, I would have to say, I think it's very fair for the commission to consider both a conservative and a more aggressive decarbonization scenario. I'm concerned about the forecast that was put forth by Bates White because I am not sure it's consistently showing you that same view between all parts of it. I just don't have enough information to say that. I look at the load forecast, for example, in the underlying forecast, and it's less than 1%. Yet Bates White has a 1.5% retail sales growth. So I feel there's a lot of value for the commission to have both views if implemented correctly and consistently between those two stages. It is, with that in mind, I guess I'd also add that the U.S. wind forecast is probably the in-between point between those two analyses. I'm not sure if you'd like me to go on and talk about differences of the assumptions themselves and opinions about how you might reach a high gas price or the lower gas price that we have. But sort of the summary situation is it is reasonable to think that there'll be a delay in decarbonization and electrification, that there'll be a lot of challenges that the industry needs to go through before they can hurdle into a world where there is a stronger and pressing decarbonization. It's also reasonable to think that energy efficiency would likely be the first play to get there, to help reduce consumer costs, that would also help depress load growth to some extent if you electrify. But with the view of a more enhanced or aggressive carbon reduction scenario, I feel the commission would benefit from having both those views in front of them. The conservative one that we do present, and I do very freely admit that we are not considering any heavy electrification in this forecast. I agree with your assessment. It is conservative in that viewpoint. But I do think having a range of opinions to view and consider and that you find trustworthy does add a bit of value, as well as make the determination more challenging.
Thanks, I appreciate that. So let me ask you a couple of questions, about some of the assumptions. So if, for example, if the commission were to accept Skipjack's numbers regarding capacity factor and ELCC, do you think that would, do you know, and this might be a little tough for you, do you think that the Skipjack bids would clear, or would you prefer to give me, as opposed to clearing, would just, it would potentially reduce the ratepayer impact?
I'm struggling with the question a little
Sorry.
bit.
If there were, Skipjack had higher capacity factors, and also if you added the higher capacity factor and the ELCC into your analysis, the change in the ELCC, would that bring down the ratepayer impact of the Skipjack bid?
The ELCC would bring down the ratepayer impact of the Skipjack bid. It would not bring it down below the statutory requirements.
Okay. And similarly, I'm just gonna pick some assumptions and see what you think about these. Similarly, what about your assumption that the offshore wind will displace only solar resources? If we were to say that it was also going to displace other resources besides solar, would that have the effect of reducing the ratepayer impact of the Skipjack bid?
Yeah, that's a very good question. I think, and it brings up several points that were raised throughout the proceedings. The ICF analysis does assume that there is expansion of resources over time. I think all the underlying analysis does have some expansion of resources over time, and largely renewable resources, whether it be wind or solar, that's underlying the basis for the price forecasts. When you add capacity, like so we add large amounts of offshore wind capacity, we do think that other capacity that would have been added otherwise would not be economic or no longer be economic. So in our approach, we did look at the resource as an alternative to not having that resource available. You need to do something because you do still need to serve energy and have reliable grid. It's fair to look at the analysis more from a, an all else equal standpoint. If nothing were to change and you just put this offshore wind in, this offshore facility in, what would happen? The dispatch, now having said that, that was a capacity decision. So we took out solar resources because you wouldn't need to build those solar resources for maintaining reliability. They also wouldn't be in the market to dispatch. What happens though is those solar resources that you're displacing are not the price setting resource in the market for energy. The price setting resource that you would displace is actually a gas facility, most likely. So had we not removed those solar facilities, I don't believe that the energy price would be significantly changed, the marginal energy price in the Delmarva Peninsula. Certainly in some hours, but in most hours you're adding the generation in and affecting the marginal price, and that's what we used to assess the facility value. So I don't think it has as large of an impact as other witnesses may.
Okay. So you're saying it may not have as, would you say it has an impact, but maybe not as large of an impact?
Yes, I think that's fair.
Okay, great. And what about the assumption of the energy price reduction effect of the skipjack projects? That also seemed to be a higher.
Yeah, the energy price, the reduction in the skipjack analysis, it's based off of a regression analysis, which has, as I understand it, two variables, load and gas prices. So given the high gas price forecast, when you modify the load, which is they're equating to the supply of the resource, when you modify that, you'll get a higher impact than if you had used lower gas prices. So I think the underlying assumption that is really affecting that to the largest extent is the gas price assumption.
Okay. Okay, thanks. Let me make sure that's everything I have. I think that's all I had. Thank you so much, Ms. Scheller. I really appreciate your help.
Ms. Schiller, thank you for assisting the commission with your independent analysis here and your candid responses to Counsel and Commissioner Herman. You recognized a moment ago that your assumptions were somewhat conservative, and I think that you characterized Skipjack's analysis as more aggressive. Would you go as far to say that Skipjack's analysis was unreasonable, or would you group the ICF, Skipjack, and U.S. wind analyses as all within a zone of reasonableness?
So I struggle with the skipjack analysis a bit because I struggle to connect the gas prices, which I think are a major driver of their forecast, to the scenario that they're presenting of a decarbonized world. When I look at gas demand in that construct, in that decarbonized future, I would think that demand is also going down for natural gas because you are switching out residential heating and systems to electrify them. When that gas demand goes down, and particularly in the long term of the forecast at significant levels, I would expect the gas price to actually be lower rather than higher. So I do struggle to connect the dots in the skipjack presentation. It's not to say there can't be a high gas forecast and a decarbonized future. It's just that I personally struggle with that.
Thank you. I noted with Witness Chang earlier today that the Henry Hub spot market price today is over $5.50, and I would not want to care to venture where gas prices will be 6 months from now, much less 20 years from now. But you do raise a good point with respect to volatility and perhaps lower usage in out years. So again, thank you for your view. Other commissioners, Commissioner O'Donnell.
Thank you, Mr. Chairman. Good afternoon, Ms. Scheller.
Good afternoon.
I have two questions for you. First of all, I'm not asking you to do this. I'm not asking ICF to perform this, but I'm asking about your opinion. I can't do that sua sponte. I don't have the authority to do that, but I'm asking your opinion of staff's recommendation to have you perform a separate net ratepayer impact sensitivity analysis with and without the TransSource project in a time frame necessary to inform the commission of that impact, should we issue ORECs?
Right. So the recommendation was to exclude that from our analysis. And those particular lines are or would tend to
No,
reduce.
can I correct you, ma'am? Can I read you what they recommend?
Yes, please.
Question, do you have a recommendation? Answer, yes, I recommend that the commission direct ICF to form a separate net ratepayer impact sensitivity analysis with and without the TransSource project in a time frame. So they want it both ways.
And I believe our analysis includes it already.
Okay,
So what the incremental work would be to have one that does not include it.
okay, now I see what you're saying. Okay,
So if we were to remove the particular lines in question from the analysis, the level of congestion would likely increase and cause an increase in the Maryland energy pricing, at least in the near term, before resources might actually modify or load changes might modify the implications over time. So I don't know. I can't tell you what the magnitude of that would be at all. I think it would result in all of the projects performing slightly better than they do now. I think the projects that are marginal in our pass-fail analysis would likely move from fail to pass in that. But I don't think it would have a dramatic effect, in terms of the dollar, over $1 impact on the net, the rate impact analysis versus the energy market analysis.
well, it's a real life scenario, and I think staff makes a good point that we probably need to understand it both ways. But I don't know how we do that. Okay, let me ask you this. I've been asking the economy expert witnesses about PJM capacity market bonuses and penalties, and there's some criticism of ICF by parties regarding your pricing assumptions, price mitigation, prices, bonuses, price penalties. How do you respond to that? Do you have any response to that criticism?
We did not specifically look at the bonus and or penalty structure for the markets. that there is a, a level of probability of performance and underperformance that would affect those bonuses. I do think that it is a small share of the overall project revenue structure, or such that we're capturing the major elements that would tend to move the needle much more than just the bonus and penalties.
Well, yeah, but the price mitigations are not insignificant. They're very significant potentially. And I'm asking about those as well. I didn't ask the other witnesses about those, but I'm asking ICF about those since they've been mentioned.
Could you point to me which specific reference?
Don't have it right now. So this is a question that I have, but I don't have the specific reference. So are you aware of where you did or did not include in your report price mitigations?
I guess I'm not sure if you're referring to just the capacity market.
Well, we can do it that way. Okay, I like straight answers, ma'am. I got to tell you, I like straight answers.
Yeah, no, we did not look at the MOPR, if that's what you're thinking of. We did assume a particular construct to the capacity market. I'm just not sure what your question is, so I'm not trying to avoid you in any way, but.
All right. Fair enough. I apologize. And I'm not sure how to articulate it other than I know that capacity prices and other price mitigations or expansions for that matter can have a dramatic impact on this analysis. And I'm wondering how you took that into account. So that's really what I'm trying to ask you.
And I think the short answer is that we simply looked at the break-even value for capacity. We did not look at alternate constructs. We did not take into risk of different constructs of the capacity market, or that potentially state policy or renewables may not be able to receive full credit. So we did not, in our assessment, consider risks to the capacity revenue for the facilities.
Okay, fair enough. Thank you. I appreciate it. Thank you for being here. Thank you, Mr. Chairman.
Thank you, Commissioner. Any additional questions? Seeing none, do council have any questions based on the questions of myself, Commissioner O'Donnell, or Commissioner Herman? Thank you, Ms. Schiller. Again, you may step down.
I didn't unmute in time, Your Honor. May I ask one?
Oh, yeah, yes. Ms. Schiller, are you still with us for a moment? Mr. Previs, right under the wire, had a question. Mr. Previs, if you could just clarify whose question you're following up on.
It's Mr. Fields and Commissioner, and one of the Commissioner's questions. I have several of the Commissioner's questions, actually.
Okay, well, if you could please just be specific, otherwise you might catch an objection.
Commissioner O'Donnell and Mr. Fields in a redirect form.
Okay, please proceed.
I just wanted, a lot has been made of the ELCC and that capacity market, and whether there were benefits or whether if you bid in you're penalized, or if you bid in and you received a capacity benefit. But in the big scheme of things, is the ELCC a very, as the rate impacts are sort of proportional in this case? I'm not asking my question great, but there's various forms of rate impacts that can be netted against the OREC price. Isn't it true that the ELCC is one of the smaller impacts compared to the other ones that you have to consider?
Yes, that is true.
Thank you. No further questions.
Okay, thank you, Ms. Schiller. You may step down now at this point. All right, we have gone through now all the witnesses who filed testimony in advance. Obviously, this morning we received the best and final offer of Skipjack. I understand that Mr. David Hardy, CEO of Skipjack, made himself available this afternoon, subject to recall. to answer additional questions based on the document that was filed this morning. So, Mr. Gunderson, do we have your client with us? Mr. Gunderson, you're on mute.
Yes, Mr.
Yeah,
Hardy
we
is available. I'm going to switch chairs with my colleague, Mr. Curran, who's going to sponsor Mr. Hardy.
Thank you. And I now see Mr. Hardy on our live stream here today. We'll wait for your attorney to be present.
Mr. Chairman,
Hi, Linda.
earlier when Judge McLean, right in the very beginning, asked counsel if something was okay. I don't know if it had to be confidential. You know who spoke on that one?
I'm sorry, can you say that again, Linda? You were very faint.
Oh, okay. Early on when Judge McLean was speaking, he made reference, trying to remember it correctly, to something, he was asking counsel something about confidential. And somebody answered, and I don't know who it was.
Yes, I do recall that.
You know who answered that question?
I'll see if counsel remembers. It might have been me, but it could have been one of the other attorneys.
Your Honor, it may have been counsel for Skipjack, Mr. Gunderson.
Oh, okay.
Okay. All right. Oh, yes, it was his client's information at issue. So, well,
I didn't hear the question either. So, but I couldn't hear the court reporter's question.
The court reporter mentioned that there was an exchange between Chief Judge McLean and some counsel regarding whether a piece of information was deemed non-public. She couldn't hear who responded. Mr. Curran just said it might have been Mr. Gunderson.
That's correct, Your Honor.
Okay, so it is Mr. Gunderson, Linda.
All right, thank you very much.
Thank you. Okay, Mr. Hardy, you still remain sworn from your attestation earlier, well, last week actually. Mr. Curran, do you need to do anything to sponsor your witness?
Yes, Your Honor. Just a few questions to get his testimony in the record. Mr. Hardy, you previously provided live testimony in this proceeding on Wednesday, November 27th, regarding Skipjack Wind Phase 2.1's application. Is that correct, sir?
Yes, that's correct.
And do you remember or recall getting a number of questions from commissioners during that proceeding?
I do.
And do you recall during your live testimony on October 27th that you responded to questions from Commissioner O'Donnell about whether during these proceedings, should you find any additional savings or the ability to reduce the bid cost, that you would be open to coming back to the commission and explaining how you reviewed your bid and figured out a way to lower your OREC price or to otherwise make your bid more competitive. Do you recall those questions?
Yes, I do.
And do you recall how you responded to that line of questioning, sir?
I recall that I stated on the record that Skipjack will always have the door open and will be always open for further discussion, and we'll try to see if there's other things we can do to try to make our bid more competitive.
Thank you. And related to your response, do you have before you two documents that were filed with the commission this morning entitled the public and confidential version of Skipjack's best and final offer?
Yes, I do.
Your Honor, at this time, we would like to have mark those documents for identification purposes as Skipjack 22, the public version of that, and 22C, the confidential version of the Skipjack best and final offer.
So marked as Skipjack 22 and 22C.
Mr. Hardy, were these documents prepared by you or under your supervision, sir?
Yes, they were.
And could you describe for the commissioners what is contained in Skipjack's best and final offer?
Yes, I can give a summary. Skipjack is pleased to present its best and final offer for Skipjack Wind Phase 2.1 to the state of Maryland for this round 2 year 1 proceeding. This offer is in addition to the comments Skipjack has already made to the commission and the state in support of Skipjack Wind Phase 2.1. Skipjack's best and final offer for its Phase 2.1 project contains the addition of more economic benefits to and job creation in the state of Maryland in the form of a wind turbine manufacturing facility, along with a reduction in its OREC price.
Thank you, sir. And can you elaborate on the additional in-state economic investment that Skipjack is committing to as part of its best and final offer?
Yes, I can. As noted in my live testimony on October 27th, as part of our phase, or part of its Phase 2.1 bid, Ørsted and GE will facilitate by and through a preferred third-party tower manufacturer the construction of a world-class offshore wind turbine tower manufacturing facility in Maryland. The tower manufacturer who will be selected will invest approximately $150 million in Maryland for the construction of the offshore wind turbine tower manufacturing facility. I'll also add that Skipjack's tower facility would bring an estimated 200 permanent manufacturing jobs to the state and approximately 648 full-time equivalent years in temporary construction jobs. It's difficult to give jobs that are construction jobs because they peak and ebb and flow, but we calculated an FTE. And the tower factory will produce 100 towers annually, generating nearly 200 million in in-state revenue annually.
Thank you. And during your live testimony, you also discussed last week the goals of Skipjack of making Maryland an offshore wind supply chain for North America. How will this facility play into that?
Yes, consistent with Ørsted's approach to the long-term economic development, this facility will be designed to be designed to supply future offshore wind projects, both inside and outside of Maryland, solidifying the state's position as a key part of the U.S.-based offshore wind supply chain well into the future.
And thank you. And is Skipjack guaranteeing any of the investment above the already $410 million that you've committed to if for some reason the tower facility is unable to be built?
Yeah, I mean, it's our intention and high confidence that we can get this tower built. But importantly, Skipjack also confirms in its best and final offer that it's willing to commit to $100 million in the form of additional in-state spending or local content, so that an additional $100 million in addition to our $410 million commitment in the event that Ørsted is unable to facilitate bringing this tower factory to Maryland. And the commission can make that additional $100 million in-state spend a commitment for Skipjack in an award. Skipjack's intent, as I said, is in committing this additional in-state spend is to just give the commission confidence that Skipjack's commitment to bringing this tower facility to Maryland, since it was brought late in the process.
Thank you. And as a part of your best and final offer, Mr. Hardy, can you also elaborate on Skipjack's proposed price reduction in its best and final offer?
Yes, as noted in our filing this morning, attached to our best and final offer was a new OREC schedule, which lowers the OREC price with a corresponding yearly decrease. That corresponding yearly decrease was detailed in attachment A of the Skipjack BAFO filing made this morning.
Thank you. And did Skipjack include any other discussion of its commitments in the best and final offer that you provided this morning?
Yes, I'd just like to reiterate for the commission, and this is contained in our best and final offer as well, that Skipjack affirms that its reduction in OREC price does not affect Skipjack's continued agreement to an explicit mechanism which will allow Maryland to capture a majority of the value of any future savings that Skipjack is able to realize through the engineering, procurement, and construction, or EPC phase of the project.
Thank you. Your Honor, at this time, we would respectfully request to have Skipjack's exhibits 22 and 22C entered into evidence.
Seeing no objection, Skipjack 22 and 22C are moved into evidence.
And at this time, Mr. Chairman, Mr. Hardy is available for cross-examination on the best and final offer.
Counsel for U.S. Wind.
Thank you, Mr. Chairman, and good afternoon, Mr. Hardy.
Hi, good afternoon.
Thank you for coming back to appear before us. Let me start with this in response to your best and final offer. The parties have been informed of the opportunity to submit a best and final offer back on October 8th. Why did the company opt to submit it this morning on what appears to be the last day or towards the very end of this evidentiary hearing?
Objection, Your Honor, to facts not in evidence.
I believe the commission can take notice of when it extended the invitation to the applicants to submit best and final offers. It was Friday, October 8th.
Yeah.
Your Honor, we were never provided anything on October 8th. I didn't see anything like that in our docket, so I continue my objection.
Okay, I don't believe there was anything placed in the docket. Mr. Curran, were your clients made aware that the wind developers had an opportunity to file a best and final offer?
We were never provided anything formally like that, Your Honor, not as outside counsel.
Okay.
I don't know. I can't consult with my other client here, but Venable was not made aware of that.
I'll sustain the objection. I'll rephrase the question, Mr. Collins. Mr. Hardy, why did you file this document at the close of hearing today?
Well, as I described, Mr. Chairman, you know, the process, we were asked the question by the commissioners on the 27th, which was the middle of last week. We recognize that, you know, the commissioners are, you know, trying to represent the state in the best manner that they can, and this is an opportunity for us. And so we spent the time really looking closely at our business case and our assumptions, and getting our internal approvals, and we tried to make sure that we could respond to the commissioner's requests to put our best foot forward here, which is when we were able to get that done was this morning.
Thank you, Mr. Collins. Your next question.
Thank you, Mr. Chairman. So, Mr. Hardy, then just to clarify my understanding, the first time that you or Skipjack was informed or invited to submit a best and final, you're saying that is in connection with the hearing last Wednesday on the 27th when you appeared. Is that correct?
I'm not sure about the specific question you're asking, but last week when I was here, the commissioners asked me if there's more that I could do, and I took that opportunity to go back into my organization and see if there was more that I can do, and that's what I did.
But that request for, is there more that you can do, that did not come any earlier than the 27th, is that correct?
I'm not clear. It was asked on the 27th. So even if I had presented a best and final before the 27th, I was asked on the 27th. So I took the opportunity to see what I could do.
But you were not, you did not submit a best and final before the 27th, correct?
I think it's semantics about the name best and final. But this is the latest offer that we've delivered to the commission for their consideration.
Mr. Chairman, at this time, I'd like to note an objection on the record. There seems to be a discrepancy between the dates in which the applicants were informed of the opportunity to file a best and final offer. Our date, October 8th, and it would appear October 27th for Skipjack. I simply note the objection on the record, please.
Objection is noted, although the witness is saying that he learned of this at trial on October 27th last week. So the objection is noted.
Thank you. Now, Mr. Hardy, your counsel indicated earlier today at the outset of hearings this morning that Skipjack would not be making its OREC pricing public in this proceeding. And I'm just wanted to confirm, is that still true and accurate to the best of your knowledge?
That's correct.
if you are awarded OREX in the time frame, say, of next month, or let's say before the end of this year, within the next month or so, will Skipjack be making its price public so that the ratepayers can know the price?
If we're awarded OREX, we're comfortable with the price of our OREX becoming public.
So if you would do so next month or soon thereafter, why is it that the company is not willing to make the price public now?
Objection to relevance, Your Honor.
Mr. Collins, why do we need to know that here?
Well, I think, for one thing, since we have just a very brief opportunity to conduct cross-examination, we might like to know whether it will be subject to confidentiality or not if we have questions about the prices that are in best and final. So from a practical standpoint, for purposes of the rest of today's proceedings, I would wish to know. But I'm also asking about it since there's so little time between, say, now and when an OREC award might be made.
I think it's clear, unlike your company, who's shown a willingness to provide some transparency with the OREC numbers, it's clear that Skipjack is of a position where they are not going to release any of their OREC pricing absent an award, at which time Mr. Hardy just stated that all of that pricing data will become public, again, if issued an award. So Mr. Collins, let's hear your question again, although I would anticipate an objection.
I'll refrain, Mr. Chairman. I think I have my answer, and I'll move on. Thank you. Mr. Hardy, in reviewing the public version of Skipjack's best and final offer filed at 9:35 a.m. this morning, at page 1, there is a description on tower manufacturing. Do you see that?
There's a section called Tower Manufacturing, yes.
It says in that section that GE and Ørsted will engage a preferred tower manufacturer. Is that correct?
Yes.
And does this section of the public version of Skipjack's best and final offer also indicate that it will be this preferred tower manufacturer, not GE or Skipjack, who will make the investments in Maryland? Is that correct?
As a result of enablements from us and GE, from Skipjack and GE. Yes.
When you were on the stand last Wednesday, Commissioner Herman asked you about the $150 million investment for the tower manufacturing project. Do you recall that?
Not explicitly, but I'm okay if you want to recap what she asked me and what I said, and then I can try to comment.
Let me refresh your memory. Commissioner Herman asked you if that $150 million investment is Ørsted or Skipjack's investment, or is it in combination with GE? And you responded that the investment would be in combination with us, Skipjack, GE, and the tower manufacturer. Do you recall that conversation?
Not explicitly, but if you're reading from the record, then I was probably the exact final commercial agreement between the three parties, A, is confidential and B, not determined. So I was talking generically about what it would take to get this tower manufacturing tower facility built. In the best and final offer today, we clarify that we're willing to backstop that commitment with $100 million of in-state spending if we can't get it done. And I would still say that exactly who's spending what on what is confidential.
So in your response to Commissioner Herman, you described this sort of configuration or this joint joint investments. But in your best in filing statement filed this morning, you quite clearly are saying it's not a joint investment. It is the preferred tower manufacturer who will make the investments in Maryland. So I think I'm compelled to simply ask you at this point, was your response to Commissioner Herman last Wednesday the correct one, or is it the best and final filing statement made this morning? Is that correct?
It's these types of arrangements are complex. It really depends. It may sound simple to the layman person or to the outside world, but which dollars go where really you can track it in different ways. So if we investing in the tower facility in Maryland, or are we not investing in the tower facility in Maryland? Those types of questions are questions that need to be determined. And all I was saying is that $150 million will be spent, is the approximate value of the tower facility. That money will be spent to get that tower facility built, and there will probably be other money spent in order to enable that tower facility to happen.
So then, if since Skipjack is now not making any investment, actual dollar investment in this project, as today's best and final offer states, is there any change to the capital expenditure projections in Skipjack's best and final offer?
Skipjack and its parent and affiliate Ørsted are making commitments that will enable the tower facility through volume commitments, both for the Skipjack 2.1 project, if awarded, and other projects within the Ørsted portfolio. So Ørsted and Skipjack are making commitments to enable this factory.
Let me ask my question in a different way, because what I'm really trying to get at is there a change to the CapEx or capital expenditure projection for your project associated with this announcement, this GE Tower project? In other words, will there be a change in the capital expenditure on the project as a result of this announcement regarding tower manufacturing?
I think the CapEx will not change, but we are carrying some costs in our business model in case there are costs. Well, because we expect costs from the enablement.
Thank you, Mr. Hardy. I have no further questions. Thank you, Mr. Chairman.
Thank you. Mr. Spivak?
No cross, Mr. Chairman.
Thank you. We will now see Mr. Gunderson. Do you have it? Mr. Curran, do you have any redirect?
No redirect, Your Honor. Thank you.
Thank you. We'll turn to commissioners. Do commissioners have questions of Mr. Hardy? Commissioner Herman, first in the batting order throughout. Commissioner Herman.
I don't know if that's good or bad, but here we go. Good afternoon, Mr. Hardy. Nice to see you again. Appreciate you coming back. Did you calculate the ratepayer impact of the revised bid?
We did put it through our model and through the ICF model, yes.
Okay, could you share those results with us?
I don't have those at my fingertips, but we can share those with you as a bench request.
Yes, please. I'd also wondering if you could also revise. Well, let me ask you this first. Are you familiar with the response to Commissioner Data Request number 9 that was filed today?
I can't say that I am, ma'am.
Okay. Well, it was, they're asking for your analysis using your, doing a study of Skipjack 2.1 and Marwin revised bid, or Marwin bid 2, revised bid 2, presumably. Are you familiar with that at all, or no?
I haven't heard that that was requested today yet.
Well, it wasn't. I have requested it before, and I've
Oh.
got it. It was filed today.
Oh, sorry, ma'am. No, I
that's
haven't
fine.
seen the results of that. I
You
can
haven't seen
probably
that?
get a copy of it if you want.
That's okay, because what I would like to do is, I'm assuming this residential impact reflects the Skipjack. Oh, it does say Skipjack 2.1 best and final offer. Okay, so this is best and final offer with both. Okay, that's what I was looking to make sure. It was hard to tell because it wasn't in the text, but it's in the statute. I mean, it's in the chart there. So, Mr. Curran, I'm going to make another bench data request, and I'd like you to do what you can, ask Mr. Kane to show his work on this chart, because all I've got is just some very, you maybe provide where the numbers came from, what the numbers are that allowed us to get to this chart. Is that something you can do?
Sure. This is in connection with bench data request number 9, Your Honor.
Yes.
Yes.
You know,
Okay. And that's the combination.
that's the combination with the best and final offers of both.
Yep.
Okay, because I just as they used to show as they used to say in math class, show your work. So
Right. So you're the work papers associated with
yes, please.
DR9.
Yes, please. And also the ratepayer impact, as I just asked Mr. Hardy for.
Yeah. And that's, I'm sorry, Commissioner, that's in bench data request 8.
Oh, I don't, is that an 8? It may be, but I'd like the ratepayer impact. I don't think we have the ratepayer impact of your revised offer from this morning.
Yeah, that 8 is ratepayer impact analysis with the best and final.
Ah, it is, okay.
And that's with the load growth as you had requested at 0.
Okay, that's fine. I appreciate that. I think I didn't see the BAFO in the chart there, so I wasn't sure what I had.
Yeah. We could have done a better job of highlighting that.
Well, I appreciate that. Appreciate you saying that. Okay. Yeah, so if we could just do number 9 then, update, show the work for number 9.
Show the work.
I would appreciate
Okay.
that. Yeah. Okay.
So,
thank you. That's all I had for Mr. Hardy. Thank you, Mr. Chairman.
Thank you, Commissioner. Commissioner, I just want to confirm what you just discussed with Mr. Curran. Mr. Curran, you stated that with respect to bench data request number 8 that we were just reviewing, that reflects Skipjack's best and final offer?
that's Skipjack's best and final offer through the Bates-White analysis with, as Commissioner Herman had requested last week, with a 0 load growth. There's been some discussion over load growth and whether that's appropriate, but this is at 0 load growth, passing both the residential and non-residential impact.
Thank you. I just one moment, please. Okay, thank you. Do my colleagues have additional questions for Mr. Hardy? Commissioner Richard.
Thank you, Mr. Chairman. Thank you, Mr. Hardy, for being with us again today. Did you have a chance to hear any of Mr. Grabowski's testimony on Friday?
I didn't listen to it, but I got a summary from my team.
Okay. I was interested on one of his answers. He was asked about the suggestion of your company that the commission consider awarding both of the companies projects. And are you familiar with that question?
I did hear a little bit about that discussion. Yeah.
Yeah. And his suggestion, and hopefully I'm saying this correctly, was that that he didn't quite think that would be fair to have the two projects with one being paid a higher OREC price than the other. And he also went on to elaborate that, again, maybe this is not quite right, but it would be fair to the ratepayers either, that in his discussions in Annapolis, he felt that that was a very important consideration that the legislators have given us, that we consider ratepayer impact. So I just wanted to get your reaction to that. This idea of would it be fair to award two different prices of ORECs, and would that be fair to ratepayers?
Look, I've said on the record last time, I'll say again, I have a lot of doubt in the lower price presented by US Wind, but it's their business, it's their commitment that they've made. I have a lot of confidence in my price. I know that I can deliver a project. I know I can deliver the economic benefits of my project. And I think that, we've all had the opportunity to submit our bids and increase them, decrease them, et cetera. And all I can say is that I stand behind my bid. I think that sometimes states pick a combination of bids that meet different needs of the state, and they look at the blended benefits across those different bids. And I guess that's part of what the commission's decision that they have to make. And so I really can't comment about if somebody should get a higher price or a lower price. I think we should stand behind the bids that we submitted.
Great. Well, thank you, Mr. Hardy. I appreciate that answer. Thank you, Mr. Chairman.
Already following up on Commissioner Richard, we did hear from Mr. Grabowski, and he stated that other states, and he may have mentioned New York and New Jersey, but don't quote me on that, set one OREC price. So you wouldn't have a situation where if a commission awarded two bids to two developers, they would not be paid at different prices. Are you familiar with that? Is that true?
I'm not familiar with that. I know for sure that's not true in New York nor in New Jersey. And I don't believe in Connecticut or Rhode Island. The only state I'm not sure about is Massachusetts, and they may have that, but I actually don't think they do there either.
In those jurisdictions, do they have similar sealed bid RFPs?
They do. Yeah.
Thank you.
Mr. Chairman.
Commissioner Linton, and then
Thank you. Thank you, Mr. Chairman. And good morning, good afternoon, Mr. Hardy. Thanks for coming back. I wanted to follow up on a commission data request that was answered last week on Tuesday. This was Commission Exhibit number 2. It was prepared by Mr. Walker, but I figured I could follow up with you since he works for you, and he should have been able to at least be familiar with his answers. Basically, the question that I raised at the time was if the commission were to modify the skipjack proposal in such a way that it was not the full proposal that you requested initially, how would that impact the commitments that the companies made? So first, I wanted to confirm that you would also confirm that the response to Commission Data Request 2 remains accurate now. That if the commission modifies it in some way, that the commitments the companies made, a full $400 million commitment may not be realized.
Yes, I don't have the exact document that Mr. Walker prepared for that bench request, but I can confirm that we see it as a package deal, that these things go together. It's all accounted for in our business case and our approvals, et cetera. And it really wouldn't work for us to mix and match different things, and that it's kind of the economic benefits of 410 million plus this new tower facility and with a penalty of up to $100 million more if we don't deliver it, are tied to the 2.1 offer and the 760 megawatts that are affiliated with that.
Okay. And I also wanted to confirm that the new best and final offer that we have just received is an addition to all of the other commitments that have already been made through the filings and the discussion of the proceedings up until this point. In other words, that this is not replacing something else, but it's in addition to what we've already received.
Yes, that's how I would categorize it. It's in addition. Everything else that we've said is still stands, and now some clarification on the details of the tower and a backstop so that the commission has an instrument to ensure that we will deliver that, and of course the additional discount.
Okay. All right. Thank you. That's all I had. Thank you, Mr. Chair.
Commissioner O'Donnell.
Thank you, Mr. Chairman. Good afternoon, Mr. Hardy. Thank you for coming back and visiting with us and presenting this updated best and final. Remind me if you know, in round one of the awards, we did award the same price in the state of Maryland to both U.S. Wind and Skipjack, did we not?
I actually thought you didn't, but I could be wrong.
Mr. Kern, do you know?
Were they slightly different? I think they were slightly different, Your Honor.
Slightly
But unfortunately, I was not involved in round one.
Understood.
But I've read your order.
Understood. Okay, thank you. I don't know why I was thinking they were the same or substantially the same, but they may have been a little bit different. So, well, nonetheless, I appreciate you being here, and just wanted to get that question on the record. So, thank you.
You're welcome.
Do counsel have questions based on the commissioner's questioning of Mr. Hardy?
Yes, Your Honor, I have just a few questions.
Mr. Collins.
Thank you. Mr. Hardy, in connection with your exchange just now with Commissioner O'Donnell, would you accept, subject to check, that in fact the prices in round one were substantially similar, were almost identical as a result of the commission's decision in case number 9431?
If that's a fact, then I accept it. Yes.
And also, if I may, Commissioner Richard asked you about pricing in other states. Specifically mentioned was New Jersey. I'm going to be very cautious here on the issue of confidentiality. So let me assure you and your counsel that I'm going to make my best effort not to use any prices. But what I would like to ask first is just a simple question about New Jersey versus Maryland, and that is why is your pricing in New Jersey materially less than your pricing in Maryland?
Objection. That's outside the scope of the questions that were asked.
Sustained, yes. Yeah, sustained.
Your Honor, may I be heard?
You may be heard.
The question did relate to New Jersey and pricing there, and that pricing is, first of all, that pricing is public, so I certainly could get into that, but there is a disparity, and Commissioner Richard was referring to it. And I would like to just explore it a little further by just asking Mr. Hardy that further question.
That's too far afield from the question that Commissioner Richard had asked the witness. So that objection is sustained.
One moment, Your Honor. No further questions, Your Honor. Thank you.
Thank you. The witness, Mr. Hardy, thank you for coming back. You may step down.
Thank you.
Mr. Maloney, I see you've had your hand up for a while. Do you have a question? Maybe not. Okay. What we'll do in a moment, we'll take a recess until 3:50, at which time we will hear closing statements from the parties. But before we do so, are there any other housekeeping matters to address prior to closing statements? Mr. Collins.
Thank you, Mr. Chairman. I believe I understood that Mr. Kane was going to be testifying also in support of the best and final offer that has been submitted this morning. Is that still to be arranged and scheduled? Will that be later today or tomorrow, or where are we on that?
Yes, I did say that Mr. Kane may be subject to recall at the end of this hearing. I don't see any commissioners actually exercising the request to have Mr. Kane reappear. I know, I think it was Mr. Previs made a note on that point this morning, but looking to my colleagues, I do not see that the commission is requesting his appearance. I just want to confirm, Commissioner Herman, are you seeking Mr. Kane?
No, I don't believe so.
Okay, I just wanted to confirm. So, Mr. Collins, Mr. Kane will not be reappearing. Mr. Curran, I see your mic is open.
I'm sorry. I'll turn it off.
All right. So we'll begin with closing arguments, starting with Skipjack, followed by US Wind, and then any other party. We'll do that at 3:50 this afternoon. Recess until 3:50. All right, we will go back on the record. Is Skipjack prepared to make a closing statement?
Yes, Your Honor. Thank you.
You may proceed.
Thank you. Your Honor, Commissioners, on behalf of Orsted and Skipjack, I'd like to first thank the Commission for the opportunity to present witnesses over the past several days and for your questions throughout these hearings. We also thank ICF, our counterparts at U.S. Wind, and all of the parties in counsel in this case who have worked hard to present their positions in a thoughtful and professional manner. Your Honors, the Commission has before it a tremendous opportunity to cement Maryland's place as a supply chain hub for the U.S. offshore wind industry for decades to come. Orsted has leveraged its longstanding partnerships to bring the Commission two of the world's leading offshore wind suppliers, Hellenic Cables and GE, who are ready and willing to work with Orsted to establish two new manufacturing facilities right here in Maryland. At this early stage in the development of the U.S. offshore wind industry, when states up and down the East Coast are competing for supply chain leaders like Hellenic and GE to call their states home, the Commission should seize on this opportunity to bring these companies to Maryland. With Orsted's leadership and financial support, Hellenic would not only be supplying Maryland manufactured array cables to the Skipjack projects, but it would also be shipping Maryland manufactured array cables up to New Jersey or up to New York or in many other East Coast states to supply those states' offshore wind projects for decades to come. Likewise, with Orsted's support, GE and its preferred tower supplier are also ready to call Maryland their home too, employing Marylanders to manufacture towers not just for Skipjack, but for offshore wind projects up and down the coast. This is a tremendous opportunity for Maryland, which will bring with it construction jobs, hundreds of permanent operating jobs, hundreds of millions of dollars of in-state spending, and substantial state and local tax revenue and economic impacts for years to come. The addition of Hellenic and GE builds on what Orsted has already delivered to Maryland through the Skipjack Phase 1 project. Orsted is the only developer in Maryland who has completed its upgrades at Trade Point Atlantic, and the only developer in Maryland who has completed investments in a Maryland steel fabrication company, achieving both of those milestones through investments with small MBE certified companies. That was the vision of the governor and the General Assembly in passing the Clean Energy Jobs Act. Promote the development of clean, renewable power and take advantage of the economic development benefits of the emerging offshore wind industry. Through Skipjack Phase 2.1, Orsted is ready to continue to partner with Maryland to deliver on those promises. And Orsted is ready to do so at an OREC price that the Maryland Energy Administration affirmed is competitive and which is lower than the price just paid by New Jersey earlier this year for the Atlantic Shores project. Orsted strongly believes in the ratepayer protections called for in the Maryland statutes, and we have shown that there is incredible value to customers to adding near zero cost generation to the supply stack. Offshore wind will displace more expensive fossil fuel generation, driving electricity prices down over the long term, and thereby benefiting customers both during and after the OREC period. When the immense energy price reducing effect of adding near zero cost offshore wind is appropriately valued, this is not a zero-sum game as other parties suggest. The Bates-White analysis is consistent with the state's renewable energy and electrification goals and vision for a low-carbon future. But as Mr. Kane explained, even if the Commission adjusts his electrification assumptions to be more conservative, the Commission can still approve 1.2 gigawatts or even up to 1.6 gigawatts of offshore wind in this case if the Commission is so inclined, while still keeping ratepayer impacts below the General Assembly's ratepayer caps. And by including Skipjack 2.1 in an OREC award with its higher capacity factor, that will allow Maryland to receive a significantly greater volume of renewable energy compared to the similarly sized U.S. wind project. Orsted supports all investment in Maryland's offshore wind industry, including from U.S. wind, which only provides more opportunities for Marylanders to obtain good paying jobs, more opportunities for a Maryland-based supply chain, and more clean, renewable generation for Maryland. In closing, Your Honors, thank you for your consideration of the skipjack application, and we look forward to submitting our brief in which we will summarize in more detail the extensive record evidence that supports approval of the skipjack wind phase 2.1. Thank you.
Thank you, Counsel. Counsel for U.S. Wind.
Thank you, Mr. Chairman and Commissioners. We appreciate the opportunity to present U.S. Wind's case before you today and last week and over the prior weeks and months. Thank you also to all the parties for their cooperation and good nature as we work through this and develop obviously a very extensive record. As I opened on my opening remarks, our application says what it says, and it contained all of the things that we've talked about over these last 3 or 4 days, and we believe that they are offered sincerely and in good faith. There's been so much discussion about investments and what is being invested and what's being committed, and there's a little bit of confusion on that, and I'd like to just address it briefly. There's been so much fanfare made about Skipjack's $400 or now $410 million investment commitment, but I would like to just point out that this commitment pales in comparison to U.S. Wind's commitment, which pursuant to its following of the 19% in-state obligation from round 1, case number 9431, that U.S. Wind commitment amounts to $570 million, as Mr. Grabowski has testified. In connection with some of the concerns that we've heard from Ocean City, we continue to take those very seriously, and we continue to work as best as we can with the leaders, with the representatives and other stakeholders in the Ocean City community. And we commit to continue doing that as time goes forward. I note that what Ocean City has suggested and has asked for in this proceeding, and as we have come to learn in the discussion and in the questions and answers, it's impossible to do, and it is outside the legal jurisdiction of the Public Service Commission. The setting of that lease area, as we all know, was done years ago through a federal process, and at this point in time, it is non-jurisdictional and simply legally impossible to undo a decision made not by us, not by any developer, but by the federal government and specifically the BOEM. So we will continue to work with them as we have, but wish to just make that clear that these requests are simply not something that we can do, nor can the commission at this time. As to the law of Maryland, I think what you've just heard Skipjack Counsel describe, they've tried to tell you the vision of the Maryland General Assembly in the legislation that passed in 2013 and again in 2019 to develop offshore wind. And we wholeheartedly agree with that statement. It certainly was part of the vision. But Skipjack Counsel has left out not only an important provision of the statute, but the heart of the statute. That heart is the rate cap. And the reason I say it's the heart of the statute, those who were involved in the deliberations and enactment of that law will remember quite clearly that the law did not pass for the first 2 years in 2011 and in 2012 because the ratepayer impact test or price caps, there could not be agreement on that, whether there would be one and how much, not until 2013. and after 3 years of deliberation was the enactment made, and with a price cap. And as we found out in the 2019 legislation, that price cap was not only sustained, but actually intensified in a small way. It is the heart of the statute, and it is not something that Skipjack wants you to focus on, but we take it seriously, and we have taken it seriously from day one, and we will continue to as well. The chairman asked the commission's consultant this morning if the ratepayer analysis of both applicants was within the zone of reasonableness. And I think everyone in this proceeding recalls her response. She was struggling with the Skipjack analysis. In connection with an objection that I have raised to the commission on the record regarding the commission's invitation to file a best and final offer, let me just make clear what the nature of this is. US Wind was invited to file a best and final on October 8th, with telephonic discussions of that invitation on October 10th and October 14th. Skipjack has contended here today that October 27th was the first that it has heard of this, and its counsel argued that there's nothing in the docket to this effect and that they had no knowledge of this. I respectfully submit, and I am quite confident, that if US Wind received an invitation to submit a best and final, I am quite sure that so did the other applicant. And if that is true, then what you have here is a material misstatement under oath on the record in this proceeding by one of the applicants. Again, I am quite confident because, in fact, the invitation that was extended to me, it was stated in that invitation that it was important for both parties to be made aware of this invitation to submit a best and final offer. Mr. Chairman and Commissioners, again, thank you for your consideration throughout these proceedings. Thank you for your consideration of our bid and our best and final. And we look forward to summarizing on brief. Thank you so much.
Thank you, Counsel. We'll next hear from Counsel for Sierra Club and the League of Conservation Voters. Ms. Miller, you have 5 minutes.
Thank you very much, Mr. Chairman. Good afternoon, Commissioners. Just for the record, my name is Susan Stevens Miller, and I am representing Sierra Club and the Maryland League of Conservation Voters in this proceeding. I'd like to thank you for this opportunity to speak to you at the final phase of this proceeding. The climate crisis is not an abstract idea. It is a real emergency impacting all of our communities. I am a lifelong Maryland resident, and the vast majority of that time I have lived in Anne Arundel County. I attended Anne Arundel County Public Schools, and my daughter attended Anne Arundel County Schools. Last Friday, the Anne Arundel County school system closed all the schools in the county. It was not for potential snow. It was not for a coming hurricane. It was due to fears of flash flooding. This is the first time I can ever remember in my life that a school district had to take these steps, and sadly, it won't be the last. In 2017, this commission took a major first step in fighting climate change and increasing renewable energy in Maryland. What should not be lost is that in this decision, the commission also demonstrated that steps could be taken to address climate change and secure our energy future while not sacrificing other aspects of our environment. The commission's balanced order showed that protecting the environment need not be an either-or position. Offshore wind projects can and must be constructed in a manner that considers and protects the surrounding environment. In your consideration of the projects before you, the commission should approve as many projects that meet the statutory directives and should place conditions on those approvals which preserve and protect Maryland's environment. Not only the offshore wind environment, but protect those individuals and the air quality for the facilities that each of the applicants is planning to build in Maryland so that those projects don't detract from the benefits of the offshore wind facility itself. I thank you for your time.
Thank you, Counsel. We'll next turn to Counsel for the Town of Ocean City, Maryland.
Thank you, Mr. Chairman. The Mayor and Council of Ocean City would like to thank the Commission for its courtesy and its professionalism throughout. This has been a long road, and one of the things that Ocean City remembers is the commitment of this Commission throughout most of the past decade to understanding the importance of the Ocean City viewshed. It's something that this Commission has repeatedly acknowledged, honored, and said that it would seek to protect as part of this process. This case represents a test of whether the Commission's commitment to protect that economic engine, that jewel of Ocean City, has real meaning. It also represents a test of whether or not Maryland can protect its shorelines, whether it can do what other states have done for their citizens, what North Carolina has done for its beachfront communities, what Virginia has done for its beachfront communities, and what even much of New York has done for their waterfront communities, is to protect their valuable and precious viewpoint, the viewshed that they have. There's no reason that Maryland cannot do the same. Ocean City is not opposed to wind energy, but we want wind energy that's located far enough away that it will protect our viewshed and protect the thousands of people who come each day to Ocean City to enjoy the billion-dollar view. When Ocean City came to the Commission previously with concerns about Skipjack's use of the 12 megawatt turbines, we were talking about 10 turbines about 20 miles from shore. At that time, the Commission decision took into account how far away those turbines would be. Now, U.S. Wind is proposing building 82 new turbines, and that would be not a massive size, and it would be as close as 12 miles from the Ocean City shore. It makes that previous debate look small in comparison. I want to disagree with my friend, Mr. Collins, on the issue of jurisdiction. Yes, it is true that the leasehold, the issue of deciding a leasehold, falls within the exclusive federal jurisdiction of BOEM. But the decision as to when and how and what kind of OREC credits falls exclusively within the statutory discretion of this Commission. And this Commission can decide whether to award OREC credits, and if so, what reasonable conditions to impose upon those OREC credits. And it does not have to use the OREC credits if they are going to subsidize a destruction of the Ocean City's beautiful waterfront views. You have heard from the mayor as to how much Ocean City's tourism contributes to Maryland's overall economy. You've also heard his testimony about how the town's position is supported by the Hotel, Motel, and Restaurant Association and the tourism industry in town, who recognize the negative impact these turbines will have so close to shore. As Robert Sullivan has testified, the U.S. Wind project will be a wall of turbines as seen from Ocean City's shores, and the iconic views of Ocean City that generations have known would be dominated by U.S. Wind's proposed project. As he has emphasized, what is not shown in any of these simulations the commissioners have seen is that the huge blades of these turbines will be in motion, drawing visibility to these projects even more. It is not impossible to protect Ocean City's viewshed here. Indeed, the developer and applicant here does not even move the turbines as far back as they could within the leasehold area. And at a minimum, if the Commission is not willing to condition the OREC awards on moving these 30 miles out, the Commission should at least insist that these turbines be located as far back in the leasehold area as they possibly can. If the Commission cannot do that, then Ocean City has to question whether there is any meaningful commitment to protect its historic viewshed. Thank you.
Thank you, Counsel. We'll next hear from Counsel for Office of People's Counsel.
Thank you, Chairman. Good afternoon, and good afternoon, Commissioners. William Fields for the Office of People's Counsel. The ratepayer impact analysis that's been discussed, taken up a good bit of discussion in this hearing, is critical for the interest of customers in the state and should be viewed as a threshold that must be met without weighing any of the other important considerations that are before the commission and laid out in the statute. The commission has heard, we've all heard a lot of information on how parts of the analysis, particularly the ICF analysis, might change with different inputs and assumptions. We had discussion today about the changing the ELCC numbers, the effective load carrying capability numbers. OPC will be analyzing that new information and providing our position on it in brief. There is a risk here that the ratepayer impact will, in the end, turn out to be higher than 88 cents per month. And with that in mind, as I said in my opening statement, we encourage the commission to avoid aggressive methodologies and assumptions in settling on a ratepayer impact estimate. On the transmission upgrade issue raised by OPC, I think we've heard some useful information from both US Wind and Skipjack. And OPC continues to recommend including a condition on any OREC award that will provide an appropriate credit to Maryland ratepayers if those same ratepayers are asked to directly pay for transmission upgrades, and as a result, lowers the obligation of developers for those costs. And we'll certainly be discussing that in more detail in our brief. With that, I thank you for your attention during these hearings, and we look forward to presenting our full position in our brief and continuing the case from there. Thank you very much for your attention. And that's the end of our closing statement.
Thank you, Counsel. And finally, we'll hear from Counsel for Commission staff.
Good afternoon, Mr. Chairman, Commissioners. We are not going to do a closing statement per se. I do note that staff's recommendations are on the record, and I would like to thank all of the parties that have taken part in this proceeding for the professional and thorough way they've conducted it.
Thank you, Counsel. So I believe the only item that we have left is to schedule the briefs and brief. It's actually just one consolidated brief. It will be due in 3 weeks on Friday, November 19th. I propose that the page limit be 50 pages in length. Does any party object? Hearing.
Skipjack does not object to that.
Okay, all right. Hearing no objections, the one brief should not exceed 50 pages. Make your best argument and file by close of business on November 19th, which is a Friday. Again, thank you to all the parties. Thank you particularly, Mr. Collins.
Mr. Chairman, if I may, just a question for the benefit of all the parties. In light of the analysis, in light of the best and finals that have been submitted by the applicants last Tuesday and this morning, should the parties expect any sort of updated or revised analysis from the commission's consultant as to compliance with the ratepayer impact test and other tests?
The answer to that is no. However, the requests that were made today by Commissioner Herman, those obviously will be circulated to the parties via email by Counsel for Skipjack.
Yes, and we will intend to do so as quickly as we can.
Thank you.
And Mr. Chairman, I have one housekeeping matter, if I may.
Please.
There were, in connection with the September 28th and September 30th public input hearings that were conducted during this case, US Wind received a number of questions that were referred to it by the commission. These were questions that came from members of the public, and the answers were not readily apparent or available, and we were asked to prepare and provide those answers back to the commission so that the commission could then forward them to the requesting parties. We have summarized those answers in a single document. We included it in our exhibits marked as U.S. Wind Exhibit number 19. And if there are no objections, I would ask that those responses be admitted into the record just to make sure that the record is complete.
Thank you. Mr. Collins, that was pre-filed U.S. Wind Exhibit 19?
Yes, sir. Yes, sir. Well, not pre-filed, but it was included for the past week or so in our list of exhibits marked as Exhibit 19. U.S. Wind responses to September public comment hearing questions.
Yes, I have that before me, a 3-page document to a number answering 4 questions. Any objections? Seeing none, U.S. Wind Exhibit 19 is moved into evidence.
Thank you, Mr. Chairman.
Seeing no other matters to discuss, on behalf of the commission, I'd just like to thank both wind developers for their interest shown and the 5 bids submitted. We recognize that this was not a complicated or simple request for proposals. We recognize that much time, effort, and expense has been spent to make these filings with the commission. The commission will endeavor to get its order out by statute towards the end of December. With nothing else remaining in this evidentiary hearing, we are now adjourned. Thank you.